Good afternoon. I will now call this meeting of the Special Committee on Reconciliation and Indigenous Affairs to order. My name is Lisa Semler, and I am the MLA for Inuvik Twin Lakes and Chair of this committee. Our first order of business is to open our meeting with a prayer, and I will offer the prayer. Heavenly Father, we ask you for your blessing and help as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of respect, joy, and enthusiasm. Give us the desire to find ways to excel in our work. Amen. Our next item is to review and adoption of the agenda. Madam Clerk.
Good afternoon. Our agenda contains prayer, which we've just undertaken, review and adoption of agenda, declarations of conflict of interest. Public matters are a presentation on the United Nations Declaration on the Rights of Indigenous People with Mr. Nuri Frame, co-managing partner of Pape Salter Teillet, LLP. And then we go into camera for committee business, followed by new business parking lot. Date and time of next meeting, which is Wednesday, April 23rd, 2021 at 1 p.m. and adjournment. Thank you.
Thank you, Madam Clerk. Are there any additional additions or changes to the agenda? Hearing none, can I have a motion to approve the agenda as presented?
I'll move that motion, Madam Chair.
Simpson? I have Minister Simpson, MLA for Hay River North, has moved and adopted the agenda. The motion is in order. All those in favor? All opposed? Motion is carried. Are there any declarations of conflict of interest? Hearing none, I will move on to our next item. Today, the Special Committee on Reconciliation and Indigenous Affairs is receiving a public presentation on the United Nations Declaration on the Rights of Indigenous People. Our presenter is Mr. Nuri Frame, co-managing partner of Pape Salter Teillet. Welcome, Mr. Frame.
Thank you.
Today's meeting is being live streamed on the Assembly social media channels, and presentation materials will be uploaded to the Legislative Assembly website. To respect physical distance requirements, several members and myself will be attending virtually. I will ask the members and the presenter to please wait to be recognized by the chair before speaking and to direct all comments and questions and remarks through me. I will now ask the members to introduce themselves for the record. Starting with myself, I am the chair, MLA for Inuvik Twin Lakes, as I mentioned. And I will start with the members that are in the committee room.
Alan Johnson, the MLA for Yellowknife North.
I'm Carolyn Cochran. I'm the Premier of the Northwest Territories, and I'm the Minister for Executive and Indigenous Affairs and the Minister for the COVID Secretariat, and I'm pleased to be here. Thank you.
Thank you. And for the members of the committee that are online, on the phone or on virtual?
Hi there, RJ Simpson. I'm the MLA for Hay River North, as well as Minister of Justice and Minister of Education, Culture and Employment.
Thank you. Ms. Marcellos?
Rita Marcellos. Rita Marcellos, and I'm the MLA for Tabacha.
Thank you. And for the committee, for the MLAs who have joined us online, can you please introduce yourself?
Kevin O'Reilly, Frame Lake.
Steve Norton, MLA for Tuna de Willowdale.
Caitlin Cleveland, MLA Cam Lake.
Jackson Lafferty, MLA Morphy.
And I think that's all we have. Thank you. I will now invite Mr. Frame to introduce himself and to proceed with his opening remarks.
Thank you very much, Madam Chair, and thank you to the Chair and to the committee members for the invitation to be here with you, even if only virtually this afternoon. It's really a privilege to be able to talk to the committee about these important issues related to the United Nations Declaration on the Rights of Indigenous Peoples and reconciliation more generally across Canada and in the Northwest Territories particularly. So thank you very much for the invitation, and I hope we'll be able to have really a good conversation and discussion today. I've got a presentation that I will take the committee through, but I'm really looking forward to hearing questions from the committee members and from the other MLAs and ministers and the Premier who are in attendance, and I really hope this can be a back and forth to some extent to unpack some of these, I think, quite complex, but again, really important issues. Just a little bit about myself. I've met some of the folks on the call today in various forums in the past, but as the chair said, I'm a lawyer with the firm Pape Salter Teillet in Toronto. I work with Aboriginal governments across the country, here in Ontario where I live, but particularly in the north. Both the Northwest Territories and the Yukon are a significant part of my practice, and I have for about a decade now worked with the Tlinchon government, which obviously relates to a number of the issues directly implicating the Northwest Territories and reconciliation in the territory. I also work with the First Nation of Nutchanayak-Dun in the Yukon, who are in the process of negotiating a transboundary claim, which overlaps parts of the Gwich'in and Sahtu settlement region. So I've had the great privilege to work with Indigenous governments in the territory and also to work with a number of officials within the GNWT over the years. And again, I'm really glad I can be here today. I do want to make clear, however, that I'm here in my personal capacity. I'm not here as a representative of my law firm. I'm certainly not here as a representative of the Tlinchon government or of any of the other clients that I work with, although obviously my experiences working with those Indigenous governments and the perspectives and insights that I've developed in my years assisting my clients will inform and infuse the substance of the presentation I'm going to make today. So, Madam Chair, should I just put the PowerPoint up on the screen and dive right in?
Yes, thank you. Mr. Frame, please proceed with your presentation.
And let me know once it's become visible on your end.
It's visible now.
Great, thank you so much. So I had the opportunity to see some parts of the presentation that the committee received last week from Mr. Isaac. I thought it was a terrific presentation, and I thought he did a really solid job of outlining the substance of the United Nations Declaration on the Rights of Indigenous People and also the various processes which have been undertaken in parts of Canada, particularly Bill C-15 federally and DRIPA in British Columbia, to talk about sort of what's going on elsewhere and his perspectives, some of which I agree with, and to be fair, some of which I don't entirely agree with, about how and if the United Nations Declaration could and should be best implemented. And so I think that Mr. Isaac did a tremendous job, and I don't want to retread old ground, so I'm not going to spend a lot of time, unless there's a request from the committee members for me to do so, really digging into the nuts and bolts of what's in the declaration or what's going on with DRIPA and C-15, but I'd like to move quite quickly into a discussion of some more specific interests that I think implicate the Northwest Territories and some views and perspectives that I have around how the UN Declaration may be useful as we move towards, or as we continue along the path towards reconciliation in the Northwest Territories. So my presentation this afternoon will, at a fairly high level, give a short overview of the UN Declaration, then a discussion about some options for implementing the UN Declaration in the NWT. I'd then like to talk a little bit about the UN Declaration and the Northwest Territories' modern treaties in particular, because in my view, the modern treaty relationship is absolutely essential to the public government, Indigenous government relationship in the Northwest Territories. And for more than, 35, 40 years, the Northwest Territories has been at the forefront of the modern treaty movement in Canada. And I think that really needs to be, in my view, an essential part of what UNDRIP means and what UNDRIP implementation means going forward in the territory. Next, I'd like to talk about sort of moving towards models of consent. I don't think we can have a conversation about UNDRIP if we're not having a conversation about free, prior, informed consent, and particularly free, prior, informed consent in the context of resource development activities. I think that's very much where the rubber meets the road, and that's often where discussions about UNDRIP start and certainly where they end. And I think that's a really important topic for us to unpack a little bit. And in my view, there's lots of opportunities there, and the Northwest Territories is already very much on this path. I'll offer some conclusions and key takeaways, and then, as I said, I'm hopeful we can move into a really active question period, and I'm really looking forward to hearing from the committee members and the other members in attendance their thoughts and having a good discussion about what this all might mean as the NWT moves forward. So, as we know, the UN Declaration is a declaration which sets the minimum international standards for the protection and promotion of the rights of Indigenous peoples. Existing and future laws, policies, and programs on Indigenous people have to be redesigned and shaped to be consistent with this standard. So that was a statement from 2007 when the Declaration was adopted by the United Nations General Assembly. And I think that really speaks to what the Declaration is about and what it's trying to do. It's trying to transform the legal and policy framework in a way which really allows the rights, the interests, the values, and the perspectives of Indigenous people to meld with and marry with the interests, perspectives, and laws of public government in a way that in much of the world has not been done, and quite frankly, in much of the world is still not being done. Although, as Mr. Isaac noted, and I agree with him, Canada is very much at the forefront of building a reconciled and modern relationship between public government and Indigenous governments around the country, with varying degrees of success from one part of Canada to the next. But I think, in my view, and we'll talk about this a bit later today, really doing an awfully good job right now in the Northwest Territories. And I think that's something that I'm going to want to keep coming back to. In my view, UNDRIP is fundamentally about Indigenous self-determination. And that's something which has been part of the conversation around Indigenous rights in Canada probably for centuries, but certainly in the modern context since Calder in 1973, and really since the modern treaty movement began in the mid-1970s, moving through the 80s, 90s, and up to today. And I think understanding what self-determination means, understanding what self-governance means, and understanding how Indigenous nations, Indigenous peoples can be self-governing and self-determining within the context of Canadian Confederation and within the context of Canada's constitutional framework is really a big part of the project that we need to be engaged in. And I think that's what implementing UNDRIP is really all about. Again, we note that UNDRIP builds on other human rights treaties. There's obviously a wide body of international law in the United Nations and elsewhere around human rights generally. And UNDRIP is, I think, an interesting next step because it's really drawing on the Indigenous peoples and Indigenous nations' own legal traditions, customs, and institutions. And again, that's returning us back to this idea of self-governance and self-determination being essential and intrinsic to what the UN Declaration is trying to do. I think we hear discourse, and I think you heard this from your previous presenter, Mr. Isaac, that the UN Declaration is an aspirational declaration. And I don't necessarily disagree with the characterization, but I do disagree with the implication of the characterization, by which I mean when we call things aspirational, we often do so in order to minimize them, in order to say that they're unrealistic, they're pie in the sky, they're unachievable, they're nice words on the page, they're motherhood statements, but they're not somewhere that we could ever really get to. They're not something realistically that we should be reaching for, because what we're reaching for can never be achieved. And I think that that's really a flawed way to understand how to approach an aspirational document or an aspirational declaration like the UN Declaration on the Rights of Indigenous Peoples. And I think we really need to understand aspirations as being not just feel-good statements, not platitudes, but rather aspirations are about charting the path towards where we want to go. They're about charting the path towards who we want to be as a country, who we want to be as Canadians, who we want to be as public governments, as Indigenous governments. And those aspirations, for me, are less about sort of feel-good, never get there statements. And they're more about being guide stars, right? They're about being a North Star that we can use to set our course and to move towards. We may not get there, or we may not get there for a long time, but it's through the process of moving in that direction, the process of being animated by those aspirations, that I think we can really see positive, concrete, on-the-ground change happen in meaningful ways that can do tremendous benefits for Aboriginal Canadians, but for all Canadians, and really, really change how this country makes decisions or how decisions are made in this country. And I think it can do so in a way which is to the betterment not just of Indigenous governments and Indigenous nations, but to the nation as a whole. And so again, and that's really the points that we're making here on these second two bullets. And you will forgive me, I have a tendency to put things on slides and then stray from them significantly when I'm talking, so you'll have to bear with me if I periodically need to sort of reorient back to where we are. So I'd like to really focus the discussion on the UN Declaration in the Northwest Territories, because I think the Northwest Territories is really a unique jurisdiction in Canada. It's unique for all kinds of reasons, obviously, just as every province and territory is, but in the realm of Indigenous relations, in the realm of Indigenous self-government, in the realm of modern treaty making, as I said earlier, the Northwest Territories has been at the forefront of that for decades, and I think is really already doing tremendously important and tremendously innovative things. And I think one of the places we're seeing that happen is in the development of new models of governance, and new modes for legislative co-development. So as we talked about a few minutes ago, at the core of the UN Declaration are these concepts of Indigenous self-determination, of agency with respect to Indigenous self-governance, with respect to decision-making, but also, and this is where that idea of free, prior, informed consent gets implicated, having agency in being decision-makers with respect to things that will impact them. It's not only government for oneself or for one's own community, but it's also governance and decision-making and agency with respect to all of those things that are happening extrinsically or externally by public governments and by industry, which will have an impact on the health, the well-being, the sustainability, and ultimately the future that an Indigenous nation and Indigenous people will confront. And I think a lot of the time, when we look at the UN Declaration and when we read discourse or we read media articles or we hear critiques, a lot of those critiques are founded in the notion that, well, you know, but that's not how we do things, right? That's not how it works in Canada. There's a way that things work in Canada, and the UN Declaration seems to be proposing a model, seems to be proposing a paradigm which is inconsistent with the way things work. So it's just not going to work, so let's just move on and get real, right? I think you hear that a lot. And I think that, at least in the context of the Northwest Territories, is misguided. Because yes, true consensual decision-making, true collaborative governance, true self-determination for Indigenous governments is in many parts of the country, something that isn't happening right now, something which is in fact quite foreign to the way things are happening right now. I can tell you as someone who sits here in Toronto, when decisions are being made in Ontario, those decisions 99.9 something percent of the time are not being made with Indigenous nations sitting at the table as partners. Those decisions are not being made on a collaborative basis. Those decisions are certainly not being made consensually or even with an aim towards consensus. Decisions are being made by public government or by industry, and Indigenous nations in much of the country, and then unfortunately here where I'm sitting today being one of them, Indigenous nations are stakeholders, they're interest holders, their voices to be considered, but they're certainly not anything more than that. They're not in the driver's seat. They're not in the front seat. They're maybe not in the back seat. It may just be that they're shouting in through the window of the car. And in my experience, and I don't want to be Pollyanna-ish about this, and I don't want to wear rose-tinted glasses about this, but in my experience, that is not the reality that currently exists in the Northwest Territories. In my experience, and I think that this has really happened during the current Legislative Assembly, and I think we saw the development of this in the prior Legislative Assembly as well, there were very innovative modes of collaborative and consensual governance being developed, which are not necessarily based, they're not, the source of them isn't in legislation, right? The source of them may be in the intergovernmental agreement, and often the source of them is in commitments to good governance. It's in policy, it's in practice, it's in day-to-day engagement, where representatives of Indigenous governments and public governments are coming together and operating cooperatively. They're operating in a spirit of consensus and recognizing that they aren't competing interest holders, and that respecting each other's jurisdictions and really embracing and enhancing each other's jurisdictions is not something to be feared, but really something to be embraced. And again, I do want to be careful that I don't come across as Pollyanna-ish on this, but it's for me a really exciting time in the NWT. And I think a great indication of this is the Intergovernmental Council, the IGC's Legislative Development Protocol, which was signed off by the GNWT and by representatives of many of the Indigenous governments across the territory late last year. So what's that, 4 or 5 months ago. And that document, for me, really reflects a new way of doing business, a new way of making decisions, a new way of developing legislation that's very made in the North, certainly, that maybe would be hard to replicate in other parts of the country for various sort of structural and demographic reasons. But when we're talking about the UN Declaration in the context of the NWT, I think we're seeing those principles at work right now. And so I think this really gets me to one of the central sort of theses of my presentation today, and something I'd really like to talk to folks about throughout this presentation and through the question period, which is, I think the NWT is already on the path. I think the NWT is taking steps, affirmatively taking steps, which are not only consistent with the UN Declaration, but are in fact really advancing the very principles of collaborative consensual governance, of self-determination, of self-governance that the UN Declaration is trying to achieve. That's already happening, and happening in really exciting ways, and in ways that are respectful and reflective of the unique political realities in the Northwest Territories. And so one of my big messages today, I think, is going to be stay the course, right? And I do worry that the United Nations Declaration, if it becomes too much of a focus in and of itself, could really distract from the successes that are currently taking place, and could result in a loss of emphasis or a loss of commitment to the things that are already happening on the ground in government-to-government relationships, which I think are changing things, and changing things very much for the better. And so again, the NWT is currently set on a path, in my view, towards a more fulsome respect for Indigenous governance and Indigenous self-determination. And that we're seeing Indigenous communities, Indigenous nations becoming active participants in spaces that were previously reserved for public government, for sort of public government officials, for the official bureaucracy. And I think that happened during the last Legislative Assembly through the development of the Mineral Resources Act in particular, but the other legislation that came through as well under ENR. And I think we're seeing it happening again during this Legislative Assembly as we begin the process of developing the regulations under that legislation, and as we also see new legislative initiatives coming forward. And this work is now being done not just under the auspices of the Intergovernmental Agreement and the Intergovernmental Council, but these protocols that are being developed very much at a day-to-day level by officials and by leaders to really say, okay, how do we do this? How do we make it work? We've got these ideas, we've got these commitments, we're supposed to work together to develop legislation for the territory in a way which is respectful, which is sort of respects our shared jurisdictions, where we come together. But what does that mean? And I think with that protocol that I talked about a moment ago is demonstrating, well, maybe it means this. Here's some ways that we can do it. Here's some ways that we can action it. And I think that those steps are really transformative, in many ways much more transformative than just passing a law which says we're going to implement UNDRIP. Because, and this is an area that we'll get to a bit later on in the presentation, but I very much agree with Tom's comments last week. A piece of legislation that says we're going to implement UNDRIP, I don't know what that means and I don't know what that does. But what I do know is that what's happening right now on the ground does mean something and does do a lot. And I think that's why I've titled the slide, "If it ain't broke, don't fix it." And I think to a large extent, there's always room for improvement and there's lots of work to be done. We'll talk about that as we go through today. But I think there's an awful lot being done right. And I think the focus for, in my sort of humble view, for the committee members, for the GNWT, and for Indigenous governments as well, isn't to focus on what's going wrong. It's to focus on what's going right and to identify ways to build on those successes, to improve upon those successes, and to use those successes to embark upon this process of gradual but significant transformative change. And so again, as I say in that third bullet, my concern is that an undue focus on UNDRIP creates a risk of abandoning these nascent but really meaningful efforts towards a collaborative model of governance in the territory, towards a more dramatic legislative approach. And I think that's very much to be avoided. I think that viewing UNDRIP as an issue to be dealt with through legislation and approaching UNDRIP as something which is all about passing an UNDRIP law risks really undermining the work that's already going on. It risks making the whole process of implementing UNDRIP top down as opposed to bottom up, which I think it probably should be, it must be. It takes the question of reconciliation and the development of these principles and practices and policies and action plans and all of those things, it takes them out of the hands of these consensual processes you already have and deals with them the way that I don't think is most effective and I don't think is most helpful. Again, I'm not trying to minimize the importance of UNDRIP, and I'm not trying to minimize the importance of, at some point in this process, at some point along the road, implementing UNDRIP through legislation, although again, I'm not entirely sure what that means, I'm going to be honest. And I think I'm much more comfortable and much more excited, to be honest, looking at how we're using UNDRIP and the principles that emerge from UNDRIP and that underpin UNDRIP, using those principles to see transformative change on the ground. Again, this is really sort of the point that I was making, that prioritizing a legislative approach to UNDRIP and the principles and aspirations in UNDRIP really risks drawing focus and energy away from the essential work that's already going on. I'm going to be quite blunt. Obviously, UNDRIP legislation is going to result in a big splashy headline. It's going to result in lots of discourse in the media and the commentariat. It's the kind of things that I understand that they can be dramatic. But I think that, and this is again an area where I really agree with Tom, that the legislation which is sound and fury signifying nothing, which is very, very impactful on the page and not at all impactful on the ground, is not legislation which helps reconciliation. And I think when we're looking at UNDRIP, we should be looking at how we can extract tools and ideas and principles from UNDRIP and operationalize those on the ground in meaningful ways in partnership with Indigenous governments. And again, that's why I've titled the slide, "Actions Speak Louder Than Laws," because it really is all about actions. Right? It's not about talking the talk, it's about walking the walk. And in my view, the Northwest Territories and the GNWT are currently walking the walk. And I think it's important to continue walking and not get overly distracted with talking. Again, I talk here about UNDRIP in the Northwest Territories needing to focus on developing more collaborative solutions, creating consensus-based spaces where policy and regulatory areas of shared interest and shared concern can be developed and discussed and worked through by Indigenous governments and public government. I really do think it's important, and again, not to criticize our federal friends, but I don't think what we need is to legislate an action plan. I don't think it's helpful to pass legislation that says there will be an action plan and that action plan will do whatever that action plan will do. I think it's much more helpful to start with action, sort of considered action taken in consultation and in partnership with Indigenous governments, and allowing that action to help shape the future. And I think when legislation is needed, the need for legislation will emerge from that action, as opposed to hoping that passing a law is somehow magically going to make things different, because as Mr. Isaac rightly said, it's not. So I want to pivot here a little bit and talk now about the UN Declaration in the context of the Northwest Territories' modern treaties. And obviously this is a big part of my practice from my work with the Comité, and is also work that I'm doing on behalf of a transboundary negotiating group. And so some of my own biases may be coming through here, and some of my own preoccupations may be coming through here, but I do think that the modern treaties are an essential part of the legal, the constitutional, the jurisdictional, and the reconciliatory framework in the Northwest Territories. And it's critical, in my view, that they remain front and center. As we all know, the objectives of the modern treaties is to advance reconciliation and to foster positive long-term relations between Indigenous and non-Indigenous peoples. The treaties, at least, are intended to, are desired to, and are supposed to provide the foundation for a relationship that's based on partnership, collaboration, and co-management. And again, those are all of the same ideas that we've just been talking about in the context of UNDRIP. And that's why I think it's so important that we discuss these two issues together, because I think that successfully entering into negotiating and entering into modern treaty relationships, and even more importantly, successfully implementing the spirit and intent of those agreements, not just the words on the page, which of course matter. I'm a lawyer. Lawyers like the words on pages. But really saying, what are we trying to do here with these agreements? What's the spirit under them? What's the promise within them? And what can we do proactively to get there? And I want to talk a bit later today about implementation. But in my view, what we do in the modern treaty relationship, when it's done right and when it's done with great goodwill and great focus and great commitment, because it's a long haul, these relationships are not going anywhere. When it's done right, we're pretty much where UNDRIP is trying to get us. We're pretty much at that point of self-government, of self-determination, of collaboration, of partnership, of a shared vision of the future, and of Indigenous governments charting a path for themselves and their people, but doing so in a way which is joined with, as partners, public governments and, quite frankly, other Indigenous governments in the territory as well. And this has been the preeminent model for reconciliation, at least in the view of the Supreme Court of Canada, for decades, right? The good faith negotiations and honor for the treaty relationship has been understood, certainly by practitioners like myself and by courts, as not a destination. I don't like to say destination because this road has no end. We're staying on this road forever and for good. But it's a huge way station in the reconciliation relationship between Indigenous and non-Indigenous Canadians, and between the Crown and Indigenous governments. And the UN Declaration recognizes this and endorses and affirms it. There are provisions throughout which note and respect and promote the importance of respecting treaties, maintaining treaties, and strengthening the partnerships that are based on treaties. And those appear in the preamble and also in the articles of UNDRIP itself. Article 37 in particular talks about the right to recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements, and makes clear, and this is important, that nothing in the Declaration is intended to may be interpreted as diminishing or eliminating the rights of Indigenous people contained in treaties. Even the UN Declaration itself puts treaties into positions of precedence and makes clear that honoring and fulfilling in a really meaningful way the spirit and intent of those treaties, and as well as the language on the page, is something that even UNDRIP sort of gives way to and holds out as a key tool in reconciling the relationship with Indigenous nations, not just here in Canada, but again, globally. And it's something that I think we really need to keep our eye on. In my view, the four modern treaties in the Northwest Territories, the three in the Mackenzie Valley, the Gwich'in, the Saulteaux, and the Treaties, as well as Nunavut, are really central pillars of Crown Indigenous relations in the Northwest Territories. And I think it's really exciting that we see new agreements coming up all the time: the self-government agreement in Delaunay, the ongoing self-government negotiations with other Satu and Gwich'in communities, the work being done by the Akecho and the Decho and the Northwest Territories Métis Nation, as well as work being done by overlap or transboundary groups, moving towards various models of modern treaty relationships or self-governance relationships with the GNWT. And I think that that's really, in my view, goes to the core of the Indigenous government relationship in the Northwest Territories, and it's something that we really need to cling tightly to and not allow to become eroded or diluted or minimized as perhaps newer, more fashionable, or more exciting things like the UN Declaration come along. And again, I'm not trying to diminish the Declaration by referring to it as fashionable, but it is a huge part of the discourse today, politically, in the media, people on the street. And that's not a bad thing. But I think it's important that we remember we've actually been doing some pretty good stuff for the past 40 years. We've been negotiating some extraordinary agreements. Clinchal Agreement is, in my view, a really, really significant step in terms of self-government and in terms of how to construct a land claim agreement. And I'm sure there's very exciting work being done at the other tables that are negotiating today. And I think we make an error and we do ourselves and reconciliation itself a disservice if we allow the importance and the centrality of those modern treaty relationships and the commitments enshrined in them to be treated as secondary or to be treated as yesterday's news, because in my view, they're not at all yesterday's news. In fact, they're very much today and tomorrow's news. And I think that we see that in Article 37 of the Declaration. I think it needs to be front of mind as we wrestle with these issues going forward. The one area where I think, well, there's lots of areas, but I think one area where I think we need to keep working, we need to keep looking at how to do it better, is the question of modern treaty, and to be fair, historic treaty as well, but modern treaty, particularly implementation. That I think everybody on the committee and all of the members in attendance, I'm sure, are well aware that treaty relationships don't stop with the signing of a treaty, they start with the signing of a treaty. And that as much work as it is to negotiate a treaty, it's a painstaking process. It takes years and years and years, and experts on all sides and multiple stakeholders, and all kinds of work goes into that process. And while it is certainly a tremendous milestone when a treaty is entered into, it is in many ways just getting out of the relationship is just getting out of the starting gate. And so figuring out ways and identifying tools to ensure meaningful, fulsome implementation of treaty commitments. And again, not just the words on the page, but the spirit and intent that underpins those words is, in my view, an incredibly difficult, but an incredibly important project. And it's a project that while we would be undertaking it with or without this discussion of UNDRIP, is a project that leads us to exactly the same destination that UNDRIP is talking about. You know, implementation really is where the rubber meets the road. That no matter how good the document is, if it ain't getting done, then it's not doing anybody any good. And in fact, and again, I think Tom talked about this in the context of UNDRIP, but it's equally true in the context of modern treaties as a tool to achieve the aims of UNDRIP, which is if the words on the page are not being fulfilled, then it's in many ways worse than not having them at all. Because what happens is there's a sense of broken promises, there's a sense of betrayal, there's a sense of letdown. And so I think that really committing to implementation is where the rubber meets the road, and it is what's going to drive these relationships forward in the years and decades to come. I think, unfortunately, there has historically been this is not just directed or even principally directed at the GNWT. I think the federal government has also fallen victim to this mode of thinking. There's been a huge amount of emphasis put on negotiation and a really sort of slapdash level of emphasis put onto implementation. That's changing now, but I think we really need to continue to be building towards a whole of government approach to identify ways to proactively implement the spirit and intent of modern treaties. Right? And by that, I mean, I don't think it's just a question of looking at the treaties and saying, what do we have to do? You know, reading the treaties as sort of minimum obligations. Okay, well, we've got to do 30 days notice for this, and if we do this, we have to do X, Y, or Z. Sure, that's there on the page, but treaties aren't contracts. Treaties are intended to be foundational relational documents. And so I would really encourage the committee members as they go forward and as they consider what to do with respect to the UN Declaration, and as they consider what to do in order to advance reconciliation in the Northwest Territories and to continue to hold the role that I think you hold right now as leaders in reconciliation across Canada, to think about how treaty implementation can become a propulsive process, which is really about government not just doing what it's public government, doing what it's required to do, but public government actively engaging with Indigenous partners to try to do as much as can be done, to try to do more than is required, and to try to really get past the words on the page and get into the spirit of the relationship. And again, I think that's very achievable. I think in the context, let's say, of legislative development, we've seen that happen through the IGC and the IGA and that protocol on legislative development that I spoke to earlier. That wasn't a contractual legal obligation. There's language in the IGA which talked about collaboratively developing legislation, yes. But that protocol and those principles of consensus, that was a government-to-government document, which was really about taking the foundation of the starting point of the IGA and building on it and sort of letting it soar. And I think that same approach needs to be used in the context of modern treaty implementation. And one area where I think that we've seen this be a really difficult part of the implementation process and the implementation relationship, and again, this is an issue that intersects very closely with the UN Declaration, particularly there in Article 4, which talks about not just the right to self-determination, about autonomy and self-government, but also about the need to finance those autonomous functions. One thing that I think we're really continuing to struggle with as we all work to implement modern treaties effectively is how to make those self-government commitments around what I would call social envelope jurisdictions, education, public housing, social welfare, all of those kinds of sort of nuts and bolts, boots on the ground, people-facing programs that are in many ways about money, right? For education, you need schools, and for schools, you need teachers, and you need textbooks, and you need desks, and you need chalk, and these days, you certainly need laptop computers. And the same with public housing, and the same with social welfare, and on we could go. But I think this is an area where modern treaty nations and their public government partners around the country have really struggled and continue to struggle. And I think in the Northwest Territories, there's going to need to be a real rethink of how funding flows, around how funding decisions are made to support Indigenous governments taking on these jurisdictions and taking them on successfully. It can't just be enough to say, well, sure, you have the right to pass an education law, you have the right to pass a social welfare law, you have the right to pass a housing law, you're allowed to draw down the jurisdiction, but there's nobody says we're going to fund it. So do what you want, but it's your discretion and you've got to find the money for it. I think that discourse, which has existed certainly in the past, needs to shift. And the way in which money flows in the territory will likely need to shift with it. It may be that the sort of Ottawa to Yellowknife to the communities approach to funding social programs will need to change. It may be that the understanding of all of these things being commissioners' responsibilities and all of these dollars being sort of Ottawa territorial government and then dispersed out from there under the auspices of the territorial government, it may be that model needs to shift. And I know that as soon as we start talking about dollars and cents, these can become very scary third rail issues because I think there's a real sense that this money is essential and this is the way that we've done things, and that having this become fragmented risks balkanization, risks impoverishing the center, risks all kinds of things. But I think it's really essential that we not be just leaving the commitments as words on a page, but that we be finding ways to proactively implement them. And I think around these self-governance jurisdictions and the funding of these self-government jurisdictions, we need to be identifying ways for Indigenous and public governments to work together to rethink the model, to come up with new models for the future, and to really do what's necessary to ensure that the treaty commitments and the vision of self-determination in the treaties and in UNDRIP is fulfilled and isn't left, and this is a Supreme Court of Canada quote, as the empty shell of a treaty promise. Before I sort of wrap up on modern treaties, and I'm coming to near the end of this presentation, and hopefully we'll be switching into sort of a discussion and question period shortly, I do want to talk about some of the obstacles that may still exist to modern treaty making in the Northwest Territories. Again, understanding modern treaty making as, in my view, an essential tool towards reaching that promise of the UN Declaration. I think that it's simply the case that different Indigenous nations have different interests, different objectives, different desires, and want different things out of their treaty relationships with the Crown. And just because it works for one group does not mean it's going to work for another group. And just because one group has a particular interest does not mean another group is going to have a particular interest. This is probably self-evident to everybody participating in the discussion today. But I think there has been a tendency around the country and in the Northwest Territories not to view treaty making as really a flexible, context-specific and iterative process. I think the model of the Dene Métis Agreement, which is going back 30 plus years, has really been used as a template and a structure, and obviously has been modified in different contexts, to a greater or lesser extent, depending on the agreement we're talking about. But I think there has been, to some extent, a one-size-fits-all with a little bit of room around the margins approach. And I think that we need to be shifting away from that. We need to be shifting towards a model of treaty making, which is really sensitive to the unique needs of an individual Indigenous nation and the contemporary reality of that nation. It may be that a fulsome soup to nuts treaty, which accomplishes that magical word certainty, I'm never sure what it means, but it's so important in the treaty context, or certainly has been as part of the discourse around treaty making. I think it's really essential that we move away from the requirements for certainty, for completion, for everything or nothing, and instead have treaty relationships and treaty negotiations which allow themselves to be flexible, which allow themselves to be iterative, which allow themselves to recognize that that we're really building consensual, overlapping spheres of jurisdiction. We're working towards collaborative modes of governance, and those may change from nation to nation, and those may change from time to time. And I think that kind of flexibility is really critical. And one sort of personal pet peeve, and again, this is not specifically about the Northwest Territories, but I think we need to move away from fixed and predetermined mandates at the negotiation table. I think they often end up being shackles, they become constraints, they limit the ability to have really good faith discussions, and they often result in treaty negotiation becoming a guessing game. How close can you guess to whatever the secret mandate is that you can't see? And I think we'd really benefit if we start moving towards much broader, much more flexible, and much more nuanced interest-based discussions, which will allow us to get there. And without going into specifics, I've been in some processes recently where government has been willing, for purposes of discussions, to abandon, if not the mandate itself, to abandon reliance on the mandate as defining the scope of discussions, and has instead moved towards a much more flexible, much more interest-based, much more, well, let's just see what happens, let's see where we get to approach. And it bears immediate and significant fruit when that happens. So I think the place that I'm going to end the presentation today is on everybody's favorite acronym, which is FPIC, which I've always thought sounds a bit like a dental procedure, but free, prior, informed consent. It's only a portion of the UN Declaration. It's certainly not the whole substance, certainly not the whole purpose of the UN Declaration, but it is what gets all the attention. It's certainly where both the excitement, the enthusiasm, and the fear and the opposition all coalesce and coincide right there at those four letters, FPIC. And so I think it's worth talking about them. And what I'm hoping I can do today is, to some extent, make the idea a little bit less scary, make the idea a little bit less threatening, and maybe make the idea actually something quite familiar, because I think this is what's happening in the Northwest Territories already. And so I don't think we need to think about free, prior, informed consent as a departure. I think we shouldn't think about free, prior, informed consent as an assault on the current norms, the current structures, the current ways of doing business, but rather free, prior, informed consent is very much the path that we're on. And going back to how I started my presentation, I think really the important thing in the Northwest Territories is to stay the course and stay on the path. So I think that these two provisions, 32.2 and Article 19, are really where free, prior, informed consent emerges in the Declaration as an important theme. The language is used throughout, and I know Tom talked quite a bit about it last week, but really 32.2 was, I think, what gets people's sort of knickers in a twist to some extent. And that's this idea that Indigenous nations need to provide their free, prior, informed consent to the approval of any project affecting their lands, territories, or resources, particularly in connection with the development or utilization or exploitation of minerals, waters, or other resources. And Article 19 then talks about it in the context of development legislation, though again, I think the Northwest Territories is already well ahead of the curve on that point. And I would say, in my view, Article 19, we can put a big sort of green check mark beside it, because I think that is now how things are being done in the NWD. But I think really the sort of monster under the bed of free, prior, informed consent, and we all see it in the papers, is the pipeline project through unsettled Aboriginal title country in British Columbia, with tremendous opposition and internal infighting between groups, and everything falls apart and the world comes to an end and the sky is falling and it's disastrous, and how could we ever let that happen? Right? That's the discourse, certainly for those of us who look at what's going on in the National Post. That's how this idea is conceived. It's a blank check or sort of a capricious veto for Indigenous people, that an Indigenous nation that's unhappy with some project or another for whatever reason, no matter how ill-considered, no matter how ill-informed, no matter how unreasonable, just needs to raise its hand and say, I don't consent, and the world and the economy and everything else comes to a crashing halt. And I'd submit to the committee members today that that's not what free, prior, informed consent is about. That's not what the Declaration is talking about. And that's quite frankly not how things work on the ground. In my view, this is a scare tactic, and I don't fully agree with the way that my friend Mr. Isaac characterized this last week. I think that free, prior, informed consent is very achievable. I think it's very achievable within the context of the current Canadian common law and constitutional order. And quite frankly, I think it's pretty close to what's going on much of the time. And I think it is not a departure from the duty to consult, which we're also familiar with, but rather it's an evolution of the duty to consult. And quite frankly, it's something which has been baked into the duty to consult from the very beginning, if you go back and look at the case law. I don't think free, prior, informed consent can or should be understood as a simple yes-no binary question, or a decision that's made at a specific point in time, or again, it's certainly not a veto. It's about, in my view, developing processes that allow parties to reach consent and to reach consensus in a collaborative way over time, iteratively, flexibly, and in the spirit of reconciliation. And I think doing that effectively de-risks development, and it mitigates rather than amplifies conflict. I think that working towards Indigenous consent, working towards free, prior, informed consent, requires developing legitimate, good faith processes for decision making where Indigenous communities have a meaningful role. We're not talking about, in my view, unreasonable consent. We're not talking about consent just because you got out of bed on the wrong side and you hadn't had a cup of coffee and someone said, can I build a mine? And you said, nah. And that was it. That's not what we're talking about. And I think using that model is really, really disrespectful and dismissive of the legitimate ways in which Indigenous governments and Indigenous nations make decisions. No one would expect or fear that kind of arbitrary or capricious decision-making from a public government in Canada, and I don't think anyone need fear arbitrary or capricious decision-making from an Indigenous government in Canada. I think reasonably, what we need to do is develop ways where these issues are confronted early. These issues are confronted in a well-informed and consensual way, rooted in listening, rooted in shared interests, rooted in identifying ways of coming together to solve problems, because so often those problems are not unique to one government or another. And I'll confess, I think my understanding of what consent and what consensus means between Indigenous governments and public governments has been very informed by my work in the Northwest Territories. And I look back, and again, I won't name any names or get into too many specifics, but I look back on the work that was done in the development, particularly of the Mineral Resources Act. And I think when that process started, a lot of people in the room, myself included, thought it could go absolutely pear-shaped. You had representatives of ITI sort of lined up on one side of a long table in a windowless boardroom, and you had representatives of various Indigenous governments lined up on the other side. And there was a real sense that this is sort of, the pro-mining faction on one side and the anti-mining faction on the other side, and we're just here to do battle. And there were a couple of mornings like that. But what emerged through the process was a real recognition, in my view, that interests were very closely aligned, that everybody understood mining is a big part of the territory's economy. Everybody understood that jobs in the mining industry are important sources of employment for Indigenous people as well as non-Indigenous people in the North. Everybody also understood that we want this to be done right. We want this to be done in a way which is environmentally sensitive, which takes advantage of best practices. And we don't want people trying to build mines in places where they're not wanted, because all that does is it leads to conflict and it leads to discord, and it harms everybody's interests. And so what happened at that table, and what happened over those months and months and months and months of building that legislation, is we realized that it was much more about the perception of daylight between us than the reality of daylight between us. And that once those perceptions were left, and again, this is perhaps me veering off into the Pollyanna-ish again, but once those perceptions were let go and we actually engaged in this collaborative process of co-development, the daylight vanished. Not on everything. There's always a little bit of daylight, but there was a real willingness when there was disagreement for one position or another to step across that divide and say, I don't like it, but I see where you're coming from, and we need to get this done. This is a joint initiative. This is a shared concern. So sure, if that's how we need to get there, that's how we need to get there. That, in my view, is exactly what free, prior, informed consent is about. And so rather than running from the concept, rather than treating the concept as a threat to industrial development, rather than treating the concept as something which is going to build an end to resource development across the North and across the country, I think we should see it as an opportunity. That if we actually approach free, prior, informed consent as part and parcel with all of those collaborative models of governance, of coming together, of creating shared spaces to resolve issues, to confront issues, to address issues, that all of a sudden something which feels scary and impossible becomes, if not easy, then entirely achievable. Again, and this is just a quote, and I do urge those who are sort of interested in this issue. I don't agree with everything he says, but I think that Dwight Newman from the University of Saskatchewan, who's quoted here, has done a really good job of trying to articulate what I think is one of the biggest misconceptions around free, prior, informed consent. And that's this fear that it's a veto. This fear that free, prior, informed consent is just a blank check to say or do whatever you want and to demand anything stop at any time for any reason. And he really understands it much more procedurally and much more from a process perspective. And again, I see it much more from a governance perspective. But I think that there are ways of approaching these ideas like free, prior, informed consent, which really reveal that they are entirely achievable in the contemporary Canadian context. And again, I think that's what's happening in the Northwest Territories right now. And I think this is really about recognizing what's going right and investing in those successes so that they can grow for the future. And this is sort of exactly where I was. We're already some of the way there in the Northwest Territories. The collaborative mechanisms we've been talking about have been built. And again, I think the NWT is really drawing the map, or has drawn the map. And now, and sort of going back to that sort of North Star guiding our destination that I talked about at the beginning of the presentation, I think now it's really about staying the course. So, Madam Chair, members of the committee, that is the end of my presentation. I'm going to close this screen so I can hopefully see your faces again. And I welcome any questions or comments the committee members may have.
All right. Thank you, Mr. Frame. I'm just going to see, okay, there. So I've made a list, and I'll just run through all of the members and if they have questions or not for who we had on the line. And if I've missed anybody, just let me know. And I'm going to start with MLA for Tabacha, if she has any comments or questions for Mr. Frame.
Thank you, Madam Chair. I think that was a much more positive presentation than last week. I think that the your guest speaker did an excellent job about the positive aspects and seemed to know more about the Northwest Territories than the previous speaker or presenter last week. You know, so I think that, you know, I'm kind of the type of person that everything's possible if you want to make it possible. Or, you know, you can do amazing things if you really put your mind to it. And I think we have an opportunity to do something entirely special for the Northwest Territories. I agreed with some of the comments that were made last week by Minister Wozniak when she said that, you know, we could do something really entirely different and something very special for the North. Because we're, you know, the Northwest Territories has a majority Aboriginal people. And the speaker today sounded like he understood some of the claims, especially the Clecho claim and other claims. He talked about the Delaney self-government agreement. And just being a former chief, I liked the speaker today because it wasn't as, it was too negative last week, I guess. I didn't realize that the guy was supposed to be a well-known lawyer, and he is. But he gave us only one side, and I thought the speaker today was more upbeat and positive. And I don't really have questions because usually I just try to listen to all the stuff that's being said, and in the end decide what is going to be best for the territories, and that's my job with the committee. Thank you, Madam Chair.
Thank you, Mr. Marcellos. Mr. Frame, did you have any comments to respond? No? Okay. I will move on to Madam Premier. Did you have any questions or comments?
Thank you, Madam Chair. Yes, I do, and I'd like to thank the presenter as well for your presentation. It's every time we get a presentation, it informs us more, and I believe in learning for life. So I thank you again. A couple of things that I did hear. I agree with the flexibility in negotiations. I think that we are trying to do that in this government. You know, various governments are at different places, and my direction is meet them where they are versus where we want them to be. So move if they're ready to move, and stand back if they want to stand back, and work as much as possible. I also agree with the money aspect. That was a huge issue, I think, for too many years. And I was part of the last assembly and last cabinet, and the philosophy was give us the money as the public government, and we will decide how best to disperse it. We've taken a different stance in this government because I do believe in self-government, and I believe in the principle of self-government, and the key word being self. So we've talked to the federal government and the Indigenous governments and said, this government will not do that. We will actually be standing beside you. It's about bringing the money to the NWT. And that's been showed, I think, over the last year and a half many times that we've worked in partnership. And that is way better for the Northwest Territories than fighting internally about who should get the money. The money needs to go to the people, is the idea, and we all work for the people if we're doing our jobs right. The one thing that I really want to thank you for, and maybe a question about, is I've been struggling with the operationalization of United Nations Declaration. I've been getting hits in the House that says, do it now, do it like BC, do it like the federal government, and I've been backing off and saying, this is not about us. That's very colonistic to say, this is what it shall look like. It's about the Indigenous governments deciding what it shall look like. And I've been seeing the fears, and I'm not sure if you can answer that, but I'm getting two sides. So since this came as a priority of this Assembly, it's caused grief. What it's caused is the Indigenous governments that haven't got settled land claims and settled self-governments are saying, maybe we don't need to do that. Maybe we throw that out the window and this declaration is going to take care of everything. And then on the other side, I've got the 5 governments that have settled land claims and self-government agreements, and they're saying, what about us? What about all the money and the time and the work that we've done? Where does this leave us? So it's put Indigenous governments in a place. And so I don't know if you can answer that or not, but maybe some suggestions around how can I operationalize this, still meet the commitment for a mandate of this Assembly, but still honor the true intent of what I think the United Nations Declaration should be, but more importantly, what I think self-government is, in my perception. So if you can help me with that way, I'd sure appreciate it. Thank you. Thank you, Madam Chair.
Thank you, Madam Premier. Mr. Frame?
Thank you, Madam Chair, and thank you, Madam Premier, for the question. I really appreciate both the question and the comments that preceded it. And certainly I do want to acknowledge the evolving negotiation approach being used in the Northwest Territories, at least in my experience. And I think that it is absolutely bearing fruit and will continue to bear fruit. And I'm really heartened and encouraged by your comments with respect to how to sort of deal with these admittedly complicated issues around the flow of revenues and handling of funds to fund various social services and doing it. How can we do it in a way which really does empower self-governing Indigenous nations to, as you say, really put the emphasis on the self and allowing nations to govern themselves. So I really thank you for those comments. But I think where your concern is lying, Madam Premier, is a concern that I share as well. And I think that these are really hard issues to struggle with. I think certainly trying to replicate what BC or what the feds have done is not an approach. If anyone asked me, and I suppose you have asked me, so I've got my moment with a microphone. It's not the approach that I would encourage for the Northwest Territories. I think it is very much a top-down approach. And I think it's an approach which privileges legislation over collaboration. And again, I think it privileges laws over actions. And I think that exploring ways, as it sounds like the GNWT is currently doing, to not just hear from Indigenous governments, but to come together with Indigenous governments across the territory and explore what the implementation of UNDRIP might mean and might look like. And I think not starting with a law is the best place to start. Starting with, okay, well, this is really about principles and ideas, and it's trying to articulate, in the sort of broadest sense, kind of a better world, right? A reconciled world. And so how do we bring together all of the various nations and peoples in the Northwest Territories to talk about what that means and how we can realize that? And I think what sort of an implemented UNDRIP relationship, for want of a better word, looks like for the Pnichon may be different than what it looks like for the Inuvialuit, or different from what it looks like for the Satu or the Gwich'in or the Dehcho or any of the other groups across the territory. And just as we talked about the need for a flexible and perhaps bespoke approach to treaty making, I think we need to understand how different Indigenous nations in the territory see UNDRIP working and how they see what they think are going to be the best and most useful tools to achieve those principles. I do think, though, and I really share this concern, Madam Premier, that there are nations in the territory who spent years and years and years at the table doing what they were told was the right thing to do to build towards reconciliation, which was negotiate a modern treaty. And I think it would be a real shame and a great harm to reconciliation and a great harm to sort of the Indigenous government-Crown relationship in the territory and in the country if all of a sudden the centrality of that relationship was shunted aside and sort of through implementation of UNDRIP, whatever that meant, all of a sudden we found ourselves in a situation where nations who had followed the path towards modern treaties now found themselves as sort of the suckers who took the bad deal, and now all of a sudden sort of wave a wand and it becomes so. So I think that's a real tension. I don't know the answer. It's something that I think about and wrestle with a lot, Madam Premier. But I think that it's really, I'm very heartened to hear that it's front and center in your mind. And I think figuring out how we honor the rights and the asserted rights and the inherent rights of groups that have not or are continuing to negotiate claims, while really affirming and respecting the modern treaty relationships for those groups that have negotiated claims, I think is a real challenge. And I think it's something that we need to continue to confront as we go forward.
Thank you. Did you have a follow-up question, Madam Premier?
Thank you, Madam Chair. I could spend the whole day asking questions, so out of respect for the committee process, I will say thank you to the presenter again and continue to listen to questions. Thank you, Madam Chair.
All right. Thank you, Madam Premier. I will go to our Deputy Chair, MLA for Yellowknife North.
Thank you, Madam Chair, and yeah, thank you, Mr. Frame, for presenting. I guess I don't necessarily disagree with what you're saying. I think you have hit on the key issues in the Northwest Territories, implementation. How do we convince public governments to give up funding? Not an easy task. And I think the Northwest Territories is well on its way to find a way to implement FPIC. I would note if it would be insane for anyone to pursue a project on settled land that is private land under a modern treaty without the consent of that Indigenous government. I think, we have cases where it clearly is a veto because it's private land, and that will be sorted out as the rest of the claims come online. But I guess I want to speak to, I don't think the BC legislation or the Canadian legislation, is going to change much in their relationships, but I do believe that the NWT can draft legislation that actually resolves some of the issues you're trying to address, through cooperation. And right now, I think one of the concerns is that we may be on the right path, but it's at the goodwill of the current government, and it's the goodwill of who is sitting in Ottawa. And I don't necessarily have the trust of consecutive goodwill of governments. And so I think legislation is one of those things that, we can bind future governments, and we can start some of this kind of quasi-constitutional conversations that have to happen in the Northwest Territories, because there very much is a debate about the future of public government in the Northwest Territories. And it'll continue to happen. We are, the GNWT by a scale of magnitude, is the largest government, both in funding and number of public servants. And that's not going to change for decades, and may never change, absent some serious political pressure. So I guess, the BC and the federal legislation aside, I'd like you to speak to perhaps our ability to, enter into some of this quasi-constitutional legislation that sets us on a path that, is a little more clear for everyone about where the Northwest Territories, and specifically public-private government, is going to be in 10, say 20 years. Because to me, that's what implementation of UNDRIP is really about, is trying to reach that consensus of where we're going. Yeah. So yeah, if you could comment on that. Thank you, Madam Chair.
Thank you. Mr. Frame?
Thank you, Madam Chair, and thank you so much for the question to the member. I take your point that sort of the current collaborative processes are to some greater or lesser extent reliant on goodwill, and that the winds change and governments change and perspectives change. I would say that while legislation might be helpful in sort of consolidating the wind, in holding the ground a bit better, we've had Section 35 for 39 years, and for decades of its existence, for no matter how robust the content of that constitutional provision should have been, it was nothing more than a license to litigate. And now we're seeing new approaches to Section 35, the sort of so-called full box as opposed to empty box approach being taken. And so if a constitutional provision isn't enough to really entrench the win absent goodwill of government, I'm not sure that legislation would be sufficient to do it either. But what I did find very exciting in the question, again, and that's not to say that UNDRIP-related legislation shouldn't happen. I was not intending to suggest that, and I'm not suggesting that UNDRIP-related legislation shouldn't be something which is being discussed now and into the future. What I was really trying to discourage was treating it as a starting place, and even worse, treating it as a destination. And I think that that's really one of the shortcomings, in my view, of the BC and federal approach. Is I think they're starting with the legislation without us having any idea what the action plan is going to be. What are we actually going to do? And I worry that once the legislation's done, there's a bit of a risk that everybody spikes the ball and sits down on the bench. And I think that what we really need to see happen is to get that collaborative process working, say, how are we going to implement and give life to these commitments? And then, as part of that sort of package of tools, absolutely legislation's, it is the most robust tool available to a legislature. And I'm not saying it should be off the table. I'm just saying that I don't think it's helpful to treat it as though it's an end unto itself, or that it's the principal tool to accomplish these things, which are inherently about relationships and about shifting modes of governance. And I think that's why I found the sort of end part of your question so exciting, which is talking about sort of quasi-constitutional change in the Northwest Territories. What do new modes of governance in the Northwest Territories look like? Does the Northwest Territories want to have a constitutional convention? There's lots of ways of doing it, but you now have governments across the territories, constitutionally respected and protected governments with spheres of jurisdiction, which don't just overlap with the jurisdiction of public government, but that intermesh and interweave with the jurisdiction of public government, and which now, through I think a lot of the developments I talked about in my presentation, have seats at the table when public government is passing legislation. And so is a sort of a quasi-constitutional process, is some kind of constitutional roundtable that really allows the various constituent groups to come together and talk about what the constitutional framework and operational reality of the territory should look like going forward. Is that the right next step? I don't know if it's the next step. I think it's an incredibly exciting step, and I would be, thrilled to get to be a fly on the wall if that actually happens, because I think the territory is really in an interesting and exciting place about talking about how governance can happen differently.
Thank you, Mr. Frame. Mr. Johnson, did you have a follow-up?
Thank you, Madam Chair. Yeah, and I think the Premier hit on the other main issue the Northwest Territory is facing is that is settled and unsettled. And I think, we, depending on the whim of which government, either Indigenous, federal, or GNWT, we're decades away from, having all of the territory in the Northwest Territories be resolved. And so there's a question here as, a public government to say, well, if that's the main tool, is it fair that some Indigenous peoples have to wait, decades for all of the parties to come together and get those modern treaties? And I don't like it to be framed as, settled versus unsettled, and that somehow that detracts from an obligation to implement the current modern treaties that are settled. But I think there is a bit of a disconnect in the Northwest Territories presently for, how the public government interacts with unsettled areas and how those conversations go, especially when it comes to having dollars flow through and devolving powers. I just don't see a path forward outside of the settled claim. And I think there needs to be some sort of option to allow that to occur, or else we're just going to have, certain Indigenous peoples without governance and without their rights for decades to come. So I guess that's just a comment too of I view implementation of UNDRIP as a bit of a floor that the GNWT makes for everyone to make sure that, that there will be different groups at different stages, obviously, but that we can at least ensure that there is a path forward for everyone. Thank you, Madam Chair.
Thank you, Mr. Johnson. Mr. Frame, did you have any response to that?
Just a very short response. Yes, I fully agree with the complexities of these issues, and I fully agree that that creating tensions or sort of dichotomies between groups or language like settled and unsettled, as though one group should be privileged over the other, whichever group it might be or whichever groups it might be, is not helpful, and it's certainly not in the spirit of reconciliation, nor is it reflective of the nature of the both inherent and treaty and other rights that Indigenous nations have. To the problem that the member sort of proposed, this takes a long time to get to the finish line. And what do we do until groups get to the finish line? And I think increasingly the question is also going to be, what is the finish line? But is it fair to say that, well, that's the destination, and once you cross the line, bang, you're in. But until you cross the line, sorry. And I certainly was not meaning to suggest that, and I don't think that anyone would suggest that. And I think that one tool to look at, and I think that is increasingly being looked at around the country, and particularly in the BC process, is much more iterative processes of treaty making. That it's not an all or nothing process. That it's not a get it all done or you don't get nothing done kind of approach. But it may be that much more targeted, interest-specific, governance-specific, right-specific, land-specific, whatever-specific agreements, which may or may not be constitutionally protected, which may or may not be treaties-like. Maybe they're interim arrangements, maybe they're permanent arrangements, maybe we're doing treaties on a chapter-by-chapter basis and we bring them into effect one after the other over the course of years or decades. I think there's lots of iterative tools that exist which allow both Indigenous governments and public government to focus their attention where they want to focus it and to put their energies and their resources where they think they'll be most beneficial and where they'll most effectively respond to the interests of that nation.
Thank you, Mr. Frame. I will move on to Minister Welsnick. Did you have any comments or questions?
Thank you, Madam Chair. Thank you, Mr. Frame. Thank you very much for your presentation. I think that's actually, I'd like to pick up right there. You said, what is the finish line? To me, I think legislation often really is a tool to achieve an end, and it is certainly not the end in and of itself, and it's one that can't always be changed and be varied depending on one's motivation or the motivation of the legislature. So if we accept that, it's an interesting conversation to talk, I find, about the declaration in the context of legislation, because we may not all agree on the end. We may not all agree on what that final end is ever going to be, but we're now talking about it in the context of consensus. And if part of the declaration is an opportunity to, enact a mode of reaching consensus, what are we legislating and what is the purpose of what we are legislating? So I'll start as that as my sort of comment, and happy to hear if you have any comments on that. But my question is actually around free, prior, and informed consent. Does it benefit and would it benefit to have an overt stated policy and I say policy specifically, not necessarily legislation, but perhaps legislation, that gives that definition, that creates the parameters of what that is so that we don't get stalled on it, that we don't get mired in it, that we are not afraid of it, that we can move forward understanding what it is going to be for the purposes of our ends? Or are we fettering ourselves by doing that? Thanks.
Thank you, Minister. Mr. Frame?
Thank you, Madam Chair, and thank you to the Minister for the question. It's a great question, and it's something that I struggle with. I mean, I haven't struggled with it specifically in the context of free, prior, informed consent, but certainly have struggled with it in the context of what's co-development, what's co-drafting, what's consensus. And I'll confess, my natural bias is not to define things like that, because I do worry we're creating boxes that we may struggle to get out of, and I do worry that once we start trying to define things, the lawyers in the room all start finding slippery slopes and start sliding all the way down, and we become paralyzed before we get out of the gate. And when I've spoken about these kind of issues in the past, my inclination has sort of been to encourage people to adopt U.S. Supreme Court Justice Potter Stewart's definition of obscenity, which was, I can't define it, but I know it when I see it. And I think I subscribe to that view when we're talking about consent and consensus and collaboration. I think a lot of these things, trying to define them in some way, undermines what they really are. And so that's, if I was in charge of the world, that would be what I would say. But I'm unfortunately, I'm not. And I have found over recent years, particularly working with representatives of your government, Minister, trying to develop the collaborative protocol for legislative development. May have got me words in the wrong order there. That there is a lot of value for public government in defining these issues, because public governments are big, they're complicated creatures. Even the GNWT, which is small compared to other provinces and territories, or small compared to other provinces. There's lots of moving pieces. There's lots of stakeholders. There's various interests. There's staff turnover, and that a shoot from the hip kind of, when it feels right, you got it right kind of approach can work really well in a one-to-one context or in a small group context. It can work really well at a single table, but when you're trying to promulgate something which is intended to guide decision-making and action across an entire government, which has, again, very different perspectives, interests, players, experiences, and then in the context of free, prior, informed consent, you're also potentially looking at sort of something which can guide industrial development that the industrial proponents outside of government and Indigenous governments can look to. I think I don't know, it'd be hard. It'd be hard, and I think there's risks to doing it, because I think there was a real risk that you start, you're trying to create a definition and instead you're creating handcuffs. And again, and I think that those lawyers' slippery slope arguments are incredibly dangerous, because everyone can always come up with a but what about if, and then the world's over. And so I really do sort of caution against those. But I think in the context of public government trying to operationalize this stuff, some degree of definition may be required, just in order to prevent paralysis, or to prevent really good faith, goodwill, people acting in the way that they think is appropriate, heading off in wildly different directions and ending up with wildly different results.
Thank you, Mr. Frame. Minister Wozniak, did you have a follow-up?
Thanks, Madam Chair. I guess you're getting to why I'm maybe asking some of the questions I've asked last week and this week, and it is precisely that as a representative of a public government, I want to operationalize the thing, and I want to do so for good intentions. I want to do so to demonstrate that we can be within the spirit and the aspiration that is contained within UNDRIP or within the declaration, but in a real way. So, I'm asking questions of, well, do we articulate a definition of the free, prior, informed consent? Does that create a benefit? Do we articulate that this is a guiding document for the GNWT? Does that create the operational component? Where do we find a way to demonstrate the goodwill, the good faith that is contained within the United Nations Declaration without fettering ourselves, without constraining ourselves, and without pushing it forward, without the participation and the relationships of those we're trying to benefit? So that is really the exact challenge, is how do we then, as a public government, do this thing in a good way? So perhaps you've just opened me up to saying that I'm struggling with the very same thing. Do you have any advice for us as a public government then? Thanks.
Thank you, Minister Wozniak. Mr. Frame?
Well, I think my one piece of advice, Minister, is you don't do it on your own as a public government. I think it's essential that it be done in partnership, right? I don't think that UNDRIP can be something that public government does for Indigenous governments or does for Indigenous people, right? And that may not have been your implication, but I think it's really the most important starting point, in my view, would be to actually begin the consultation. And I don't mean consultation in capital C, hide-and-taku way. I mean consultation, coming together and talking about interests and talking about the very question you just asked me. Here's this thing, these 4 magic letters, these 4 magic words. that scares the hell out of people on one side and is sort of a lodestar on the other side, and nobody's exactly sure what it means. And, you've only had two presenters to this committee so far, and we both disagree with each other about what it means. And I'm sure you could have 6 more, and you'd have 6 more opinions. And so I think what's most important is that what free, prior, informed consent means in the Northwest Territories is what the Indigenous nations and the public government collaboratively, consensually think it should mean in the Northwest Territories, right? And I don't think it really matters what they meant at the Secretariat in New York City when they passed the Declaration. I don't think it really matters what I think or what Dwight Newman thinks or Tom Isaac thinks. I think what matters a great deal is for the governments that will be working with and living within the system that's built. I think that they need to be architects of the system right now from the very beginning and all the way up. And I can tell you that one of the things that sort of aided me in transitioning from my sort of somewhat more shoot from the hip perspective on how do you define these terms like collaboration, co-development, things like that, into thinking they could to some extent and maybe need to some extent to be memorialized in writing and defined, is by having done it. Right? It was the experience of being, particularly at tables in the Northwest Territories, where we just did the messy work of listening and hearing and getting mad and walking out and coming back and talking and everything else. And again, it was through that we started to say, okay, this is how it can work. This is how it might work. And then it became a process not of trying to come up with a definition to put it on a page, but rather it became a process of trying to distill a shared experience and to use that to inform the way that it would be actioned going forward in writing. And I think that that's really a starting place, is sitting and talking to Indigenous governments about, well, how is free, prior, informed consent something you're experiencing? Or how do you want to experience? Or when it's happened, how did it happen? What did it look like? How did it work? And then from there, you start to build a shared knowledge base and a shared sort of a shared lens through which you can look at the world and you can look at, what actions to take from there on that basis. Again, I hope that wasn't too abstracted, but that would be those are my reflections on that, Mr.
Thank you, Mr. Frame. I will now move on to MLA for Montfouille, Mr. Lafferty. Did you have any questions or comments? Hello? All right, I will move on to MLA for Frame Lake. Mr. O'Reilly, did you have questions or comments?
Yes, thanks, Madam Chair, and I want to thank Mr. Frame for his presentation. I just want to pick up on a couple things. I think he's right in saying that I think we've done a pretty good job at defining co-management on a resource development, resource management side through the land rights agreements and even some of our public government legislation. We haven't really done that, I think, very well on the social, economic, financial side, and I think he's suggested that that's something that we really should be doing some more work on. And of course, I think then we start to get into issues around constitutional development, which is, I think, where some of the responses to Mr. Johnson's questions sort of took us. So I just would like to get some further comment from Mr. Frame on that. Is that the next stage of evolution for the Indigenous governments, public governments, and as we get more or all of the governments with agreements, modern treaties in place, it looks like I think we do need to have some way of defining what the overall relationship is between public government and Indigenous governments. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Mr. Frame?
Thank you, Madam Chair, and thank you to Member O'Reilly. Yes, no, I think you're exactly right, and I think we need to be reassessing and redeveloping and redefining what the relationship is between public government and Indigenous governments. And I think that really has been the positive course of Canadian law and Canadian government since the 70s, right? Is that we have seen this, the model historically was unbelievably, atrociously, appallingly top-down, right? And we don't need to sort of talk about that history, much of which was south of 60. But it's a grim history where Indigenous governments were essentially destroyed, were dismantled, and became subject to the whims of public government, and often subject to the whims of an individual Indian agent who was there and sort of controlling how things would work. And we've seen this really gradual but very optimistic transition over the last many years, probably starting in the 60s, and really picking up speed with Calder and the modern treaty movement in the 70s. And I think we've seen the growth and the recognition of the role of Indigenous governments as governments. And I think that became sort of turbocharged, that may be an overstatement, with the inherent right policy in 1995. And when we started to see constitutionally recognized Indigenous governments. And I think in my view, and again, I'm not sure that I can tell you what the nuts and bolts of getting here would look like. I think it's a fun conversation to have, and I don't mean fun to diminish it. I think it's an important but enjoyable conversation to have, is how we continue this process of transition towards really a mosaic of governance in the Northwest Territories, where we no longer are thinking in terms of a center and a series of subordinates, of one real government and a bunch of other little governments, rump governments, with limited or constrained areas of jurisdiction, but rather we're understanding governance in Northwest Territories happening in overlapping, interlocking ways through a mosaic of governments across the territory with differing constituencies, differing priorities, perhaps differing jurisdictions, but understanding how those can be complementary and mutually supporting. Right, it's not a situation any longer where we should be looking to public government to simply support or fund or delegate authorities to Indigenous governments. Indigenous governments are not delegates of public government. They have inherent jurisdictions, and they're exercising those jurisdictions within their spheres and for their communities. And I think developing models which allow that mosaic to really be equitable and productive would be hugely helpful. And again, this is again maybe a little bit abstracted, because I think these are issues that are very much at the cutting edge, and I think it's very much to the credit of the member and to all of the members of the committee and the Premier and ministers today that this is the conversation we're having, because I don't think we're having this conversation anywhere else in Canada. This is a very, very, very cutting edge conversation that we're talking about. Not how do we write UNDRIP law, but how does UNDRIP inform constitutional renewal in the Northwest Territories in a way which redefines the relationship between public and Indigenous governments. And again, I think we're on exactly the right path, and I think this discussion is exactly the right place to go. But I think, quite honestly, a lot more talking would need to happen, and I'm not sure that I can say where it should go or where it should end up. It's probably not my place, and I don't think I'm smart enough to figure it out, even if it were.
Thank you, Mr. Frame. Did you have a follow-up, Mr. O'Reilly?
Yes, thanks, Madam Chair. Yeah, I would really love a chance to have an offline conversation with the guest at some point about the Mineral Resource Act. I was in the last assembly when it was developed and brought forward. It was kind of crunched at the end, but and I do want to compliment the work that the Indigenous governments did. Did we lose our speaker, or?
I'm still here.
Oh, great. Okay. Sorry. So I did want to say that I think the Indigenous governments did a fantastic job at protecting their rights and interests during the development of the Mineral Resources Act. You know, there were some significant inroads in the free entry system. Benefits are now going to be part of maybe even tied to mineral tenure. I think there was some tremendous work done there. Unfortunately, I don't think that happened from a public perspective, but I guess where I want to go with this is I haven't really seen much discussion about and how to recognize and incorporate the fact that we have an executive branch of government. We also have a legislative branch, and what role do regular MLAs play in this whole system of trying to build reconciliation and implement treaty rights. How do we recognize the role that regular MLAs play, standing committees play in all of this? But I'd like to get some thoughts from Mr. Frame on that. Thanks, Madam Chair.
Thank you, Mr. O'Reilly. Mr. Frame?
Thank you, Madam Chair. Yes, and thank you to Mr. O'Reilly for the question. No, I recall these issues being live issues before the Standing Committee, and as the MRA, but the other legislation as well, was moving sort of through the legislative process. And obviously, to some extent, I really can't opine on the internal operational decisions within the GNWT. Not so much, it's both not my place, but also I don't think I have the knowledge to be helpful there. But I certainly do think that it's absolutely right that that government is not just the executive branch, and that as we look towards models which really see Indigenous governments being partners in legislative development, I think there's a really important conversation to be had, which is what happens as legislation moves from the developmental phase into the legislative phase, right? And I think we're having these same discussions with other governments, with the federal government in various contexts, which is, there's one set of relationships with the executive, and maybe with elected officials in the executive, but it's often with representatives of various ministries who have been there through a number of years, and where relationships exist, and then all of a sudden you get to the door of the legislature, and it kind of things go off into the legislative process. And just as I think I hear the members sort of expressing a concern about the legislative branch being excluded, maybe that's the wrong word, but not as participatory as perhaps they could have been or might wish to be in the development process, I think that same apprehension exists on the part of Indigenous governments, which is you spend all of this time and do all of this work, and then things move into the legislative process, and there's a real apprehension, maybe not required, maybe not right, but an apprehension that you were in the driver's seat and now you're not even in the car. And I think that those tensions really need to be thought about. And again, I think this is where, again, we get back to constitutional renewal, because we have a lot of presumptions around sort of the roles of the various branches of government. And I'm certainly not going to try to sort of deconstruct the Westminster model for us this morning. I think it's probably, again, quite above my pay grade. But I think we do need to figure out how we can build a process which allows for engagement from Indigenous governments right through the legislative development process and right through the legislating process. And similarly, there may need to be opportunities for touch points or connections with the legislature and Indigenous governments earlier in that process. And I think that those are really important conversations that we should all be continuing to have.
Thank you, Mr. Frame. I have Mr. Who do I have here? Oh, MLA for Trinity Williday.
Yeah.
Mr. Norm?
Yeah. Masicho, Madam Chair, can you hear me? Can you hear me?
I can hear you.
Okay, good. Yep. Thanks. I was having some trouble yesterday. I'm glad I got to have that straightened out. Yeah, I want to thank Mr. Frame for that presentation. It was very thought-provoking and positive. And I want to share with the committee and the other MLAs about an observation I had in December. I was invited in my role as chair of the AOC to sit on a meeting at the IGC meeting here in Yellowknife at the Explorer. And there was a moment that really just, I brought up so many questions in my mind, and I thought, wow, we're doing some really cool trailblazing work, and it was when they were doing some of the co-drafting, and I made a comment to the entire to the people that were in attendance that I said, this is this is trail breaking stuff, but anytime you do any kind of work like this, you're going to get growing pains. You get bruised, but you know what? You can share your victories too, but you can share some of your struggles too. So that's the good thing about this. And that's what I want to say about this whole process that I've experienced so far. But in terms of the modern treaties and some of the comments I've heard, I can't help but wonder, try to find a path forward where you have Government Canada, our government, and our First Nations and any governments, Aboriginal governments up here in the north. And how do we move forward? And I keep thinking about game theory. Trying to find a path forward where you get the most benefit for each party going forward. And for me, like I said, this will be very thought provoking for me. I'm going to go back and I'm going to take this back. I'm going to think about this, and I'll probably have to do a lot of research on this. But I just want to say thank you and to Mr. Frame for that. And that's all I have to say. Mr. Joe.
Thank you, Mr. Norm. Did you have any comments, Mr. Frame?
Just a quick observation. I mean, it's really heartening to hear Mr. Norton's comments about attending that IGC meeting, because that's very much been, I don't go to the IGC meetings, but I've been at various working groups over the years, and been very much my perception as well that this is groundbreaking stuff, and that we are at the leading edge, certainly in Canada, of how these things can be done. And I totally share and embrace, again, personally, not speaking for any of my clients, this notion that, when you're in it for good, you're in it for bad. And that the part of this is that, if you're going to take the victory lap, you also have to take the punches. And I think that's something that we're really, I think, and I'm hopeful that we're seeing happen, and we'll continue to see happen, which is this real sense that everybody is in it together, differing interests, differing objectives, perhaps, but that there is a shared commitment and a shared ownership of what comes out of these processes. So I really thank the member for his comment.
Thank you. I think that's it for the members online. I have a couple of comments, and I want to thank you for your presentation. I like the way that you worded the aspiration feel-good statements, but when you say to continue, we need something to chart our path. Like if we don't use this tool to start charting the path, and even though in the Northwest Territories, we're so unique that, we have Inuit, we have Métis, we have First Nations, we have land claim organizations, we have, there's just, we have band councils, we have so many different governments. Like you come to Inuvik, where I'm from, and you've got the bands, and you got the Nitet Gwich'in, you've got the Gwich'in Tribal Council, you got the Inuvialuit, you got the Inuvik Community Court, you've got the Town Council, you've got, it's like you've got enough leaders here for and we have 40,000 people in the Northwest Territories, and in Inuvik we have all these leaders, all these great leaders, in one small community. And when we talk about UNDRIP, it's like, how do we all get on the same page? That, those are how do we all start talking on the same page just in our community alone, when we have a mixture of, we have the Métis local as well here. But my question, and I've always said this statement, and I've heard it over and over again. It's not my statement, nothing about us without us, And so when we think of UNDRIP, and we think of consent, and we think of devolving programs, where I fall into is social programs, right? So how do, when we go back and we say, okay, if we're going to self-govern, like we have in Inuvik, we have two organized, we have the Gwich'in Tribal Council, we have the Nitet that are doing a community self-government, we've got Inuvialuit doing the regional self-government, and they're all working towards self-government, but yet we have a community that's also split 50-50 of Indigenous, non-Indigenous. But within that Indigenous group, you've got the split again of Inuvialuit, Gwich'in. So how do you, these are always throughout the territories, my questions, and I guess that's kind of the issue is, we want to self-govern. We want to be in charge of services and programs for ourselves. We have non-Indigenous people living in our community, and I know I've had this discussion even with the Premier, and it's like, we don't necessarily want to leave anybody out without anything, but do we have in Gwich'in, running their own, the Inuvialuit running their own, and then the GNWT running for all those who are not, and those are some of the things that I think with UNDRIP, when we start to move down those paths, we talk about this, this way of doing things for ourselves and being responsible for ourselves. So these are like where in a small community of 2,000 people, like we have so much diversity here to try think of the whole territories. Did you have any comments on, within your workings with all the groups that you've worked with?
No, I think those are excellent questions, and I certainly share what I hear is your apprehension about sort of a balkanization, right? Not wanting to avoid some scenario where there's the A's are in this school, and next door is a different school, that's for the B's, and there's a school beside that, that's for the C's, and there's a school beside that, that's for the D's. I mean, we've seen that model play out in various ways around the world in various contexts, and rarely is it a tool for unity, and rarely is it a tool for bringing people together. But I think that's one of the reasons why I've tried, in very much an aspirational way today in my comments to the committee, to talk about collaboration and consensus as being really fundamental tools, to talk about this really being we operationalize so much of this through relationship. Right? It's not through, here's yours, you go your way, here's yours, you go your way, here's yours, you go your way, and never the twain or the thrain or the four, whatever that may be, shall meet. And so I think that understanding how we operationalize self-government, understanding how we operationalize consent in a relational context and in a collaborative context is really essential. And there are ways that it can be done. I mean, for the Nisga'a, for example, in northern British Columbia, they work with the province to provide education throughout the Nass Valley, which is where their traditional territory is, where their settlement lands are. They have the jurisdiction, but they operationalize it collaboratively and cooperatively with public government, recognizing that there are students and teachers who are Nisga'a, who are not Nisga'a, who are both non-Indigenous from other Indigenous communities. And I think that those are the challenges that we need to confront. And in some parts of the territory, Inuvic's probably uniquely complicated, as is Yellowknife and a few other places. It's probably easier in Wekwati or in Gamete, where you have a little bit less demographic complexity, and less in the way of overlapping, not competing, but overlapping jurisdictions. So again, I think that these issues can really only be resolved when you create a space for them. And I think this presentation up here has moved from the legal to the philosophical, and I'm not sure if that's helpful or what was expected of me today, but I do think it needs to be about creating a space rooted in those principles and really understanding and articulating those principles, and then confronting these issues of shared concern. And I think from that, it may be that people go, yeah, this is the right way to educate all of the kids, but whatever it is, everyone gets a morning a week, which is different, or we collaborate on curriculum development in the following ways. So we really front load a lot of the input. And I think front loading is hugely helpful. And I think in the same way that land use planning is a way to front load pre-prior informed consent, right? Because if you build it in when you're building the system, then the system will roll out in a way which really reflects that. So but again, I certainly hear the member in the chair, my apologies, in the complexity of these issues with overlapping jurisdictions, and I think we really want to avoid letting them become competitive to the extent possible.
Mm-hmm. Yeah, and I guess that's kind of where I feel like we don't want, like you said, we don't want a fragmented territory. We still want to be able to be strong and do things together throughout the territory, because we're all part of the Northwest Territories, I feel like. But and I think that's where that intergovernmental council table is starting, where I see, and I think those are first steps. And I think the points that you've made, I think the way that the Northwest Territories is collaborating and working together, Indigenous groups, with GNWT, with the municipalities, I think these are, even though we set it as a priority to implement UNDRIP, we are off the record implementing it in areas. So thank you again for your presentation.
Thank you.
Do you have any final comments or anything to the committee before we're...
No, I just want to express my appreciation for the invitation to be with you this afternoon, and how much I really enjoyed speaking to you, but really more than that, speaking with you, and the questions and the issues that came forward. And I really do want to reaffirm how exciting I think what's happening in the NWT is right now. And I think that the questions that were asked, they're all of the same questions that I wrestle with, and I think they really reflect that these are urgent issues, but I think that people in the room and on the call today are coming at them in really interesting, exciting, and positive ways. So no, it was really a privilege to be with you today, and I thank you for the invite.
All right, thank you. I'd like to take the opportunity to say thank you very much to Mr. Frame for providing the presentation to us today, and enjoy the rest of your day. This concludes the public portion of our meeting. Thank you, Mr. Frame. Is there a motion to go in camera? Member MLA Johnson has moved the committee in camera. The motion is in order. All those in favor? We will now